colleagues, hello, a very good afternoon to you and welcome to this free webinar on safeguarding and data protection. I can't say that it is the most fascinating topic, but it's certainly something that as DSLs we well and truly need to know about. And essentially what I want to do today is talk you through a number of different areas that I hope will give you an extra layer of assurance around handling the data protection aspect of our safeguarding work. And we should be together for about 40 minutes in all to take you through a number of different areas. I want to get to a point where you really do understand data protection in the context of safeguarding. You sort of understand and recognize what the latest changes are in legislation, particularly the Data Use and Access Act of 2025, and what those changes mean to you in your day-to-day work. I think it's really important as we go through this to reflect on our own practice, but also to reflect on practice that's previously been highlighted by regulatory bodies, such as in this case, the Information Commissioner's Office. And we're going to talk a little bit about what they do as we go on. We're going to talk about some practical skills. So as we get into the session itself, we're going to have a look at an example case record from CPOMs and look at how we would redact that if such a scenario arose where we needed to respond to a subject access request. And then to round off, I'm going to give you a bit of a checklist that you might want to use in such a scenario where you are required to respond to a subject access request. So that's the plan. My name's Lewis Donald. I'm the Principal Safeguarding Partner at EduShield. Prior to founding EduShield, I was a Executive Safeguarding Director at a multi-academy trust, and I've got a real passion for making sure that DSLs have access to the right level of knowledge, the tools and the resources that you need ultimately to do your job and make children that little bit safer within your setting. So with that in mind, I want to start by just talking you through the timeline really of how we've got to where we've got to in terms of data protection. And interestingly, it goes all the way back to 1984, which for anyone that's done my single central record session will know that I quite enjoy going back in history to look at where things originated. And the ICO was founded initially as the Data Protection Registrar. It was the organisation set up to monitor and track the use of data, be that personal or organisational data, across initially the UK government and then broadly put out to the private and the public sector as well. And the Data Protection Act was introduced not that long after that, but most significantly in 2016, we had the introduction of GDPR, the General Data Protection Regulations. Now, you might remember at the time that when the GDPR came into play, we all had to do online e-learning modules and really sort of to get our head around an area of our work which was so deeply rooted in legislation that it always was and still is a bit of a kind of a throwaway comment to say, well, I'm not a GDPR expert. We then had the challenge in 2020 of Brexit, and Brexit, of course, brought about a number of changes to legislation, in particular legislation that linked back to sort of EU-bred regulations. And as a result of that, and as part of the Brexit deal that was apparently oven ready, the UK GDPR Act was brought about, which essentially introduced the UK version of GDPR, broadly the same as what it was, but it rooted itself in UK law. Time skip forward from there, we got to about 2022, where there was a recognition by government that actually we needed to do something to look at GDPR and make sure that it was workable within the context of the United Kingdom, and in some ways try to simplify responding to subject access requests and give people ultimately that little bit more confidence when it came to information sharing more widely. Now, for education, we have only recently had what's known to us now as the Schools Data Protection Toolkit, which, if you've not seen, is a really, really useful tool created by His Majesty's Government to ultimately walk you through all aspects of GDPR in the context of education. It's accessible via the government's website, and if you haven't had a look at it, I would implore you to have a look at it, as it is a really useful sort of quick reference guide when working through some at times challenging data protection scenarios. And then there was a bit of a lull, really, up until 2025, where the Data Use and Access Act was given royal assent. And in essence, it's that piece of legislation that I want to talk to you in a bit more detail about today. Now, I think it's important to say from the outset that this is not necessarily a new piece of fresh law. It is a piece of law that adds in sort of amendments and regulates and adds new regulations into the existing data protection legislation. So a lot of the sort of stuff that's contained in this £44 piece of law, if you want to buy it and have a read through it, is essentially adding extra lines and sort of amending lines that are already in that Data Protection Act, with the view that they can ultimately sort of expand the recognised legitimate interests, they're the reasons that we share data, to increase flexibility around data access and sharing, and to really focus in for a significant chunk of this piece of legislation in making specific provisions for children's data as well, making it that little bit easier for us as DSLs to share information with confidence, but also have that extra layer of sort of reassurance when it comes to responding to subject access requests, in particular when they relate to child protection data. Now, as we go through this session, I'm going to talk to you about where this new piece of legislation fits into the existing Act and give you some top tips and tricks as to how you can apply that within your own setting when responding to data protection inquiries. But the first thing to sort of ask ourselves really is, why does this matter to us? GDPR is something generally in schools and in multi-academy trusts and local authorities that sits with a data protection officer or a data protection lead. And that's great to an extent, but actually a sort of really heavy chunk of data protection work ties in with safeguarding, because whenever we're sharing information, we need to have that safeguarding mindset to ensure that not only are we being compliant in ensuring that the data we do share is done in a legitimate way, but also making sure that, especially if we're sharing information around children, that that information isn't going to go on to harm a child or place a child at an elevated sense of risk. Now, with that in mind, whenever we're doing safeguarding, as a DSL in a school, as a trust safeguarding lead, we constantly are making decisions or relying on data, be that our CPOMS data, our multi-agency sort of meeting notes, our internal logs, even the actions, everything that we write about a child in the context of their life at school becomes data. Now, when we start thinking about that as a designated safeguarding lead, a really good sort of tip really for you is to start thinking about the data that you have access to and sort of mapping that out. Do you, within your own school or your multi-academy trust, have a really clear grasp and understanding as to what safeguarding data that you manage? We know the obvious places: CPOMs, the single central record, personnel files, etc. But actually thinking more broadly than that, we know, for example, on CPOMs or My Concern or whatever system that you use, we're often uploading into their multi-agency documents, social care assessments, meeting notes, etc. As a multi-academy trust safeguard lead or as a DSL, it is really, really important that we know where that data is stored, but also that we have appropriate systems in place to actually manage that data, to ensure its security. We rely very heavily on the premise that our online systems are secure, and we'll accept that they are. But actually, having secure data goes beyond just having an online system that holds everything in one place. There's been a recent example that the ICO have published where a primary school was publishing, publishing is a strong word, but putting up CPOMS data onto a smartboard which was overseen through a window. That in of itself is a data breach. And a role for us as the designated safeguarding lead is to make sure that we are being the custodian of that data, ensuring it's safe, secure, and shared appropriately. So with that in mind, let's start to think then about the legal frameworks and guidance that exist for us to support us in our day-to-day jobs as designated safeguarding leads. Now, with everything in safeguarding, there is, generally speaking, a piece of guidance or a piece of legislation that we can turn to or rely on to get some sort of answers. The challenge for us in the data protection context is that this legislation is very, very complicated. However, to put your mind at ease, I want to draw your attention to the key elements of this legislation, letting you know what does it actually mean. People talk often about the Data Protection Act, but what actually is it? Well, the Data Protection Act is the core piece of legislation that sits alongside GDPR that sets out how personal information about us and sensitive data, data such as addresses, pay information, child protection information in our context, must be collected, used, stored, and shared. And it has in there really specific rules for safeguarding, education, and children's services. It acts as that umbrella piece of legislation that pulls in everything to do with children's data, adults' data, and generally speaking, the data that an organisation holds on an individual. This new piece of law, as I mentioned earlier, updates and reforms the Data Protection Act. It serves to clarify the lawful basis like legitimate interests. It strengthens rules around children's data, and it ultimately modernises how organisations should document, share, and access information. As I said earlier, it is very much a refresh of this Data Protection Act and not a new set of rules in of itself. There are, in saying that, a number of sort of tweaks and changes to the Data Protection Act that sit within this Data Use and Access Act. A lot of them really, as a DSL, we don't need to pay all that much attention to because they relate, broadly speaking, to sort of how data controllers act, how data processors should sort of track and analyze impact assessments around data, etc. But there is one area that is quite key for us, and that's the new stop the clock rule around subject access requests. And it's subject access requests that I want to touch on with you now. So in terms of subject access requests then, what are they and what does it mean when we receive one? Now, the definition in the schools toolkit and in the legislation itself is this. A subject access request is a type of information rights request that lets people access personal data a school holds about them or somebody they have parental responsibility for. Now, that's a very broad definition, but it tells us if we were to break it down, and we enjoy doing that with law, that ultimately a subject access request is somebody's way of coming to you and saying, I want to know what information you hold about me in your systems. Full stop. That is all that there is to it. But that being said, getting it right and feeling ultimately confident that you're sharing the right information is just as important. I mentioned earlier about the Schools Data Protection Toolkit that His Majesty's Government has put together. And there's a really clear section in there around dealing with subject access requests, which you can use to literally walk through step by step when it comes to receiving one. But what I want to do now is talk to you in a little bit more detail about how we use that information and how we use that guidance to inform the way that we respond to data protection requests. Now, the first thing to note when it comes to subject access requests is that they can be made in any format. It's not for us to dictate to the requester how they should make that request. A subject access request can be made verbally, it can be made as part of a complaint via a letter, text message, an email, but once an individual has made that request, you can't ask them to change the format that they've made it in. So to bring that to life, if you were to, for example, receive a complaint where somebody within that complaint says that they are making that access request to see the information that you hold about them, you can't then go back and say, oh, well, actually, I've picked up in that complaint that you want to make a SAR. Our process for that is this, therefore you need to follow this other process. Once somebody has indicated that they wish to utilize this legislation to make that access request, really it's out of our hands at that point. We have to act on that request. Now, with that in mind, it's important we understand who can make a subject access request and whose information can they request to see. Now, the first one is relatively obvious, themselves. If I'm the requester and I want to submit a subject access request, I can only ask for information about myself. If I have parental responsibility for my child, I can make that request on their behalf. If the child's over 13 years, however, they fall back into that themselves sort of bracket. So you'd need their authority to make that sort of release that data in there. But a person with parental responsibility can still make that request. It would just need to be seconded by the child aged over 13. And then finally, in there, the more or the lesser known one is around somebody that they care for. So if you have, for example, a foster carer or somebody with a special guardianship order where they have that legal right to access the information, then if the child's under 13, they can make that request themselves. If over 13, with the child support, they can indeed make that request of you too. Now, it's important to note in there that in most cases, when an individual makes a subject access request, you're going to need to ask for identification from them. Now, the identification or the purpose of seeking identification is ultimately to get around that sort of anxiety that we may feel if we get an email that comes into us requesting data through the subject access request route and you're not 100% sure whether or not the person making that request is indeed that person. And the legislation allows for you to go back to that person and ensure that ultimately they are indeed the person, that they have that lawful right to make that request. But there's a slight caveat in this. Requesting identification shouldn't be a barrier to the lawful release of information through the subject access request route. So what we mean by that is that ultimately, if you know the parent, if you see the parent come into school every day, you have no doubt that that parent does indeed have parental responsibility for that child. Then so long as you are able to record the rationale, you don't need to then go back to them and say, Mr. Smith, Mrs. Smith, whoever, I see you every day. I know full well that your little Jimmy's mum, dad, or parent, but actually I still need to see your driving license and your passport, whatever. If you know who they are, it's for you to make that decision and to record in your own way that ultimately you're satisfied that that parent is indeed who they say that they are. Now, you're probably thinking that actually a lot of the subject access requests that you might have received in the past or you know are going to come into you in the future are going to say, actually, I want all the information that you hold about me. Now, it's important to know at this point that simply asking for all the information you hold about me isn't technically unlawful. You do have the right to be able to go back and try refine that request. You can't ask the requester to narrow or reduce their request. You can simply ask for clarification of what specific information that the requester is looking for. And this is a key element of the new legislation where you can stop the clock. And we'll talk about timeframes in a minute, but ultimately what we're saying here is that if you get that request in for all information and you go back and say, actually, we hold X, Y, Z on you, what is it exactly you want? That gives you that ability to stop the clock, stop that statutory timeframe, whilst you go back into that system to ultimately try and find the information that they are indeed looking for. So let me give you an example then. A college student has requested has received a warning about their attendance in a post, the sort of stuff that goes out quite regularly. The student decides to submit a subject access request. They're not really sure what it is they're asking for, so they ask for all the information that the college holds on them. Now, again, bearing in mind that we can't go back to them and say, actually, we think that you need to ask us for less. What we can do is go back to them and say, actually, we hold a large quantity of information about you, including your registration, attendance, child protection, coursework, correspondence, etc. You can go back and say that and say, yes, whilst we can send you all this data, if there is a specific piece of data you want, you may be able to receive it quicker if you specify what it is that you're looking for. Acting in that way is lawful because ultimately you've not asked a student to reduce their request, you've simply asked that they clarify exactly what it is that they want from the pool of information that you've told them is available for them. Now, it's really important that we do go back and try to refine these requests because ultimately we do have a relatively short time frame in which to respond to requests for data. The Data Protection Act tells us that a full subject access request response must be sent to the requester within 1 calendar month. Now, Again, if you're in a scenario where someone's asking you for a mass volume of data, that can be incredibly challenging. So again, this new piece of legislation builds on the existing statute that is in place around the Data Protection Act to give you a further 2 months, 2 calendar months, to extend that deadline by, ultimately giving you 3 months to respond to that subject access request. Now, it's really important to note that that is a maximum and it's not a target. It is very much, and the legislation and the schools toolkit really reinforce this, that actually it is your responsibility to ensure that you still expedite that request and you get it to that person as quickly as you possibly can. Now, just a quick note for us in schools. Legislation is clear, as is the school's data protection toolkit, that the school holidays, it doesn't make a difference to that 1 calendar month response, which can be particularly challenging if you receive subject access requests at the end of a school term. You still have to respond to them within that month. That being said, if you have a legitimate reason why you can't respond to that request within 1 calendar month, for example, all of your staff are not in school, nobody's working, then it is appropriate for you to go back and say, actually, we need to extend this period to allow us time to pull together that information. You're not necessarily saying that you are going to reject it or that you're in any way delaying it. The reality is you don't have the staff, therefore you don't have the ability to pull that information into one. But it is important to note that school days don't count. This is about calendared days. Now, as we start to refer to the Data Use and Access Act, it tells us in there really clearly that the data subject is only entitled to such confirmation, personal data, and other information as the controller is able to provide on a reasonable and proportionate search. That is the legal way of saying that where you're making the search for this information, it is for you to decide what is a reasonable and proportionate search. Now, as some of you may know, I was a police officer, and in policing, you're told that you can essentially do anything to a degree, so long as it is justified, appropriate, proportionate, and necessary. But ultimately, the burden of proof is on you to be able to justify what is appropriate, what is proportionate, and what is reasonable. And the GDPR places the same expectations on us here. It states that there is a high expectation on us to provide the information in a SAR and to conduct searches that would be reasonable and proportionate in the circumstance. It goes on to say, as I mentioned a moment ago, that it is for you to justify why a search is unreasonable or disproportionate. Simply asking for a high volume of information doesn't, by its very nature, make a request unreasonable or disproportionate. A person, a requester, is entitled to that information. It is our duty to ensure that we are carrying out the searches that are necessary to get hold of that information and pass it on. This is a really, really delicate line for us. And actually, unless somebody is coming to us and asking for more and more and more information from sources that we either don't have access to anymore, in which case we tell them we don't have access to it anymore, or in a scenario where, for example, they're asking for information that may belong to third parties, it is, you must search the sort of the assets that you have available to you. And we like sort of serious case reviews and case precedent in safeguarding. So I want to draw your attention to this case, which sort of brings to life that challenge around proportionality and sort of taking necessary steps to sort of source that data. And it comes from a High Court ruling in respect of Mike Ashley, who some of you will know, I think was not John Lewis, Sports Direct, Newcastle Football Club, etc., where he essentially put a subject access request into the HMRC asking for all information held in relation to him as part of a tax return query. Now, in this scenario, the HMRC came back and they said that actually they're going to limit their search to that one department which deals with tax returns. Mike Ashley argued that actually the HMRC should have looked across all of their systems to gather all personal information that's held about him on there and share that with him. HMRC argued that wasn't reasonable and proportionate. Mr. Ashley took them to a High Court judge who made the ruling that the HMRC had not met the reasonable and proportionate standard required when responding to a subject access request. And the judgment went on to say that organisations must conduct genuinely thorough searches across all relevant systems and teams. Now, if we start thinking about that in the context of safeguarding and in the context of child protection information, that means that we don't just solely look on CPOMs. It's for us to look on our MIS system, our communication systems, our team systems, email systems, anything that we have access to where we could reasonably believe that we hold information about a child or a young person or the person that's making that subject access request. When we find that information, though, we then have to start to ask ourselves, is it safe, is it appropriate, and is it lawful to share that information? How do we do that? We do that through the process of redaction. Now, this is the part where when I speak to DSLs and trust safeguarding leads, and even myself as a trust safeguarding lead, I've been in that position of asking myself, what should and what shouldn't I redact? And with safeguarding, we tend to at times try to overcomplicate things, or sometimes really do err on the side of caution and over-redact, or in some cases under-redact, which can be really, really dangerous. So what I want to do now is just talk you through what the legislation tells us and what the school's data protection guide tells us when it comes to redacting information that we're going to share out as child protection information as part of a subject access request. And the main piece of legislation we'll rely on here is this element, which tells us that we should redact personal information that identifies anyone other than the person that the SAR is about. This is known as removing third-party information. As we've said all the way through this, when responding to a SAR, it's our responsibility to provide the requester with their personal data, but not the personal data of others. Therefore, there's a few sort of tips and tricks here that we should start thinking about if we find ourselves in a position where we're asked to maybe review some files that are going to go out as part of the subject's access request, or as a DSL where we're compiling that child protection information to support with the furnishing of that information. Before we do that review, we need to ask, who is the SAR about? Is it about the pupil? Is it about the parent? Or is it about both? If the subject access request relates to the child, then we need to be redacting any information about other people. Just because it's the parent requesting it doesn't mean that we have to include that information. We are releasing the information about the subject who has requested that data from us. We need to double check that the person who's making that request is actually entitled to receive the child's data. We do that mainly through checking parental responsibility. And we also need to understand through the request, what is the time period, or if that sort of refinement request has been made, what are the expectations on us in terms of what we do need to provide to the requester? Because it's that information in the whole that helps shapes what should be disclosed and ultimately what must be redacted. Now, before I go on to starting to look at what it is indeed that we need to be redacting, I think it's really important that we remember that where we're making a decision to redact elements of a child protection file or any information, that we keep a record of our decision making around that. Why did we make the decision to redact that information? What was our legal basis? Which again is, why did we think it was justified? Why did we think it was appropriate and necessary to withhold that information from the requester? That's really important because if a person isn't satisfied with their subject access request return, they're entitled to go and make an appeal request to the Information Commissioner's Office and progress that all the way through to the High Court to ultimately get a judgment on that data release. So holding back that decision rationale is really, really key. Now, in terms of separating personal data from non-personal data, this can be really challenging when it comes to child protection files. So when we're reviewing child protection files with a view to releasing them as part of a subject access request, we need to sort of really consider carefully that information line by line and ask ourselves, does this information that I'm releasing relate to the data subject, the child, or the parent, if it's the parent requesting information about themselves, etc.? Does it relate to somebody else? Parents, siblings, other children, staff, neighbours, referrers, etc.? Is it professional opinion about the data subject? We can't withhold things from a subject access request because it makes us feel uncomfortable, or it's potentially embarrassing, or potentially damaging reputationally. That is why, of course, we make sure that our case recording systems and processes are as robust as possible. This is still their data, even if it's a professional opinion. It's about them, it's talking about them, it's information held related to them. Therefore, it still gets released. So what should we normally redact? Well, names of other children is quite an obvious one. It goes back to that principle of redacting third-party information. Sibling details that relate to them, not the SAR subject. Parent and carer's personal details if the child is the data subject. Addresses, phone numbers, criminal allegations about other individuals. Staff personal details beyond their professional role, and we'll touch on what that means in a little bit. Chronologies relating to other children, particularly important if we're using online systems where you can link in other students to those records, but also minutes from multi-agency meetings that reference other families or information that that family isn't legally entitled to or aware of. Now, when it comes to deciding what it is that we can redact, it isn't just those sort of more obvious things around third-party information, but we can also make a judgment call on redacting certain information. We can refuse to comply or redact a SAR if we believe that a number of things have occurred. But most importantly, we believe that releasing the information would cause serious harm to a child. If we, for example, have a child protection record that talks about a child's disclosure of some form of abuse against a parent, there may be a criminal justice process going on, or it may be that you're supporting a child through that disclosure process as they're building up to making their own report into, say, the police or social care. If we know that releasing that information to the parent is going to ultimately cause that child any form of risk or harm, then we need to be really careful about that and make that decision to say, actually, we're not going to release that information to you because we have that lawful, legitimate exemption in mind that we believe that doing so could place that child at further risk of harm. So let's sort of bring this to life then, and forgive my sort of makeshift attempt at making a CPOMS file, but this is a bit of an example for you. So what we have here is, as part of a subject access request relating to Ebony, a parent has requested all information held on Ebony, who is 8 years old. Because she's 8, we don't need to ask Ebony for her approval. The parent has parental consent. We know who Ebony's parent is. She's in school every day. We know her. We've recorded somewhere as part of this data protection process that we're satisfied that Ebony's parent is indeed Ebony's parent, and therefore they are indeed legally entitled to make this request. But we now have to ask ourselves, what is it that we are going to redact from this record? Now, if we go back to the principle of personal data for other children, well, we know that the linked pupil in this scenario is Sajid. So the first thing we're going to do is have a look through that case record and remove any or redact any information relating to Sajid. In this case, it is his name. Again, that line-by-line review is really important here, and we're going to look at an example of what happens if we don't do those line-by-line reviews in a moment, but getting that right is really, really key. Second off, we're next going to have a look at the information that is unrelated to the requester. So if you remember a moment ago, we've got that action created in there by Lisa Miller, who said that she's spoken to the social worker for Sajid, James. James is planning an unannounced visit to that family home tonight due to concerns about potential abuse from Sajid's father towards him and his sister. Well, that quite clearly is information that's unrelated to the requester. Therefore, we're going to use that exemption and we're going to redact that element of the document. The final thing is in terms of professionals' information. So you'll note in here that actually professionals' names remain, and information that's already known to the family stays there too. The family know that they have a social worker. They know that the child has been excluded. They know that she's had a fight with a child. All we're releasing is the data and the information that sits behind that. Lisa, Kerry, and Paul, and James has been redacted because he was part of the other one, but all those professionals are acting in their professional capacity. That's not necessarily, whilst it's personal information about them, it isn't their own personal information at this point. They're not acting as Lisa, they're acting in their professional role. Therefore, we are able to release that information as part of that subject access request that exists in there. So if you think about this in the context of your CPOMs or your My Concern, as you go down that left-hand side, where we've had actions recorded by certain people, we can't redact those names in there because they're acting in their professional capacity. It's information that that person has recorded about, in this case, Ebony. So the key message in here is that we're not overcomplicating this. We're just applying those 4 basic rules. We're getting rid of personal data about others. We're getting rid of information that's unrelated to the requester. We're maintaining those professional roles and the professional details that are in there, and information that's already known to the family remain too. This applies too to the documents that exist around those CPOMS records. One thing that it is important to know is that if you have child protection minutes, child in need meetings, we've all been to those child protection conferences where the chair will generally open by saying this information shouldn't be released without the consent of the chair. It's our duty in that case to go back to the local authority or whoever chaired that meeting to say we've had this subject access request. We intend to release this redacted version of the document. And it is why in most cases child protection SARs exercise that 2-month extension, because it's that element of the process that can take a little bit of time that's in there. If you have notes that you've made about child protection meetings, team around the school meetings, etc., they are still pieces of information held about the child on your systems. They're your original notes. They must be disclosed. However, we still apply those redaction rules in there. It's really important too that when we're dealing with child protection data and sort of releasing child protection data, that we carefully consider what it is that we're sharing. Not through the lens of reputational damage, but ensuring that any information we release doesn't compromise any sort of external investigation, be that through children's services or via the police. But secondly, that any information we share isn't potentially going to go on to harm the child too. I want to draw to your attention a recent case that really sort of pulls this together. And it is a reprimand that was issued to Birmingham Children's Trust, which is the Children's Services Department of Birmingham City, in a scenario which I'm sure any DSL on this webinar will be able to relate to in one shape or another, where a social worker's not been able to draft danger or harm statements from the available notes, so they've accessed minutes from a separate strategy discussion that's taken place between West Midlands Police and Birmingham Children's Trust, which has basically drawn together concerns about a family. That information has then been pulled across into the danger and the harm section of a child protection plan. The child protection plan has then been sent out to the family, and it contains that sensitive information relating to the child, the family, and a police investigation, which led to a position where the investigation was compromised, but also could have placed children at harm in there. The ICO were notified of that breach, they went through a process, and they decided to issue a reprimand to Birmingham Children's Trust. And the ICO have the power to do that. They can issue reprimands and they can go all the way through to issuing quite significant and serious fines too. So getting this bit right is not only important through an organisational lens, but this information here could have really significantly impacted the safety of the children in this case. So what are the key lessons we can take from that then? We know that we must treat redaction as a safeguarding responsibility, not an administration task. It's not for us to look at redaction and say, actually, this is just an admin task where I've got a document I've got to work through and scribble off. This is us looking at it and ensuring that actually the information we release is lawful, but also the information we release isn't going to go on to place a child at risk of harm elsewhere. So, to close off, then, let's start to think about sharing safeguarding information. Now, there is a bit of a misconception when it comes to the ICO, GDPR, data protection regulations, etc., about sharing safeguarding data. And essentially, the ICO have gone on a bit of a campaign recently to really promote to designated safeguarding leads and to school leaders that their clear message is that data protection is a framework to help you share information. It's not there to prevent you from sharing information to safeguard a child. Now, we see this in practice a lot in a lot of local authorities when it comes to making MASH referrals. They're getting a lot better at it now, but local authorities certainly went through a point of saying, we're not accepting a social care referral from you unless we have the family's consent. Now, this new piece of legislation gives us that power to be able to say to the local authority, I believe I have a legitimate basis to share this information with you, as I believe that it will positively impact the safety and well-being of the children or the data subject that I'm sharing that information with you on. So actually, as the ICO have made clear in their recent sort of public campaign, ultimately, if you're in a position where you receive a call from another professional or a school, and your primary purpose for sharing information is to protect that child, it is for you to do just that. Protect the child. It's not there solely to protect the data. It's really important when we look at CPOMS records in particular, and I keep referring to CPOMS, but obviously other software exists as well, that you record in that child's chronology that you've shared that information, you've held those discussions, as is outlined in Keeping Children Safe in Education, and you really clearly capture why you felt it was necessary, proportionate, relevant, timely to share that information, and explain in that action log how you ensured that the information you shared was secure. So, for example, if you've received a call from a professional, you've asked for a contact number to call them back on, maybe through the Children's Services switchboard, and you've shared accurate information too. You've taken those reasonable steps to source the right information and share it in the appropriate way. This new piece of legislation, and indeed the ICO's guidance and the school's data protection toolkit, is really, really explicit when it says that you do not need consent to share information if a child is at risk of harm, or if you believe that it would place the child at greater risk of harm if you didn't share that information, or if consent can't be reasonably obtained. If you're in a position where you can evidence that you have tried your damnedest to get hold of their parent, to tell them that you've got this concern about a child, that you feel that that family needs additional support or would benefit from early help, which ultimately would meet that safeguarding definition about promoting their well-being and safety, you can't get hold of them, you've tried every method possible, but you believe that delaying any longer could draw out the harm that that child's experiencing or place them at a greater risk, you do not need their consent to share that information. But you do, as I said all the way through this, need to be really clear about your decision making and why you made that decision. What is your purpose for sharing the information? The data protection legislation and the Information Commissioner's Office is really, really clear, where it says that safeguarding a child is a compelling reason for sharing information. And you can share all the information you need to with an appropriate person or authority in order to safeguard a child. That doesn't just mean children's services and the police. If you've got a child that's moving to another school, for example, that's where this comes into play. If you've got information that can promote the safety and well-being of that child, you have a legitimate reason for sharing that information to safeguard and protect that child. Subject access requests, information sharing, data protection, there's a lot in there. But actually, we just need to take a really lawful and simple common sense approach to it. But what I want to leave you with is a number of sort of actions that you could take away and a bit of a information redaction and sharing checklist, which isn't the most Gucci of titles, but if anyone has any better suggestions, I'm open to taking them. But Here's 6 sort of points that you want to sort of consider when you are reviewing a subject access request, you're considering your lawful basis for sharing information, or you are just in your day-to-day duties sharing information about a child or an adult or any sort of scenario related to safeguarding. Firstly, confirm identity, purpose, and lawful basis. Who is requesting the information? Why do they need it? And is the legal basis clear? Is there a public task, such as responding to the police? Is there a vital interest and safeguarding condition, such as promoting their safety and well-being? Identifying the data subject and the scope of that request. Being clear whose data it is that you're disclosing, what time period or instant is being covered, and which part of the file are relevant. Using that power you have, as we mentioned earlier, to go back and not try to reduce the request, but refine down to exactly what it is that they're looking for. Separate personal data from third-party data. Highlight what relates directly to the child and what relates to other children, adults, and families. When it comes to subject access requests, applying those principles we said earlier, and yes, I will send you the slides, look at redacting the third-party information or unnecessary information, or information that ultimately could identify third parties, relate to allegations. They might not be legal as they're potentially involving criminal justice processes, or if you believe that actually sharing that information could impact the safeguarding of that child. Apply exemptions where appropriate. Withholding information on a safeguarding grounds is perfectly okay, so long as you've recorded your rationale really clearly. And if you believe that in sharing that information you're going to cause that child harm, prejudice an investigation, breach confidentiality, or conflict with the child's best interest, then you use that exemption. And finally, most importantly, getting somebody independent to record your decisions and share them securely. Have somebody else, regardless of your position in the hierarchy, look over that review before it goes out to ensure that you are both satisfied that your reasoning and your lawful basis is absolutely right, and that you're only sending that data through in such a way that is through a secure, agreed channel to the recipient you expect it to go to. Ticking off all those areas is a really basic way of giving yourself that extra layer of confidence that you're taking the right steps in the right direction when it comes to data protection. So some key data takeaways, some key takeaways for you relating to data protection. As we said in this, data protection, the new data protection legislation strengthens the importance of purpose-driven justified sharing. You need to understand lawful basis and you need to record your reasoning. We saw it in the case of the Birmingham Children's Trust, but you need to make sure that, as it states in Keeping Children Safe, we record all decisions we make in relation to a child and why we made them. Redaction protects children and prevents breaches. It's not there to protect the organisation from embarrassment. And as we said in there, that Birmingham case shows how easy it is to get this wrong. People don't make data protection breaches maliciously, but they very easily get it wrong through basic human error. Good standard sharing procedures and documentation makes good safeguarding information sharing practice. That's a bit of a tongue twister. And with all that doom and gloom, I want to leave you on one sort of more pleasant note, which hopefully will reassure you. And this is on the front page of the ICO's website. It says, "Don't worry about receiving a fine or another penalty when you share information in good faith to help identify and safeguard a child that you believe is at risk of harm. You won't get in trouble with us. It will never breach UK data protection law to share all the information you need with an appropriate person or an appropriate authority." And I think that's a really, really good way to reflect on data protection and to reflect on child safeguarding and the link between the two. Colleagues, I really hope that you found that interesting. EduShield is here ultimately to support you. And whilst you're on the call, if I may, I want to tell you a little bit about EduShield Plus, which is our new system that's coming into play in January. And I'll soon be going out for volunteers to come and join us for free to have early access to our resource bank, our WhatsApp community, our online webinars, our sort of takeaway tools, policy templates, the works. But more important than that, you will, I'm sure, be aware that tomorrow Wicked comes out. And in that spirit, I'd like to give you the first look at the trailer for EduShield Plus, influenced, of course, by Wicked.
I knew you. You're the only friend I ever had. I have been changed for good. But only one that mattered.
So keep an eye on that. That's going to be out on LinkedIn tomorrow. But in the meantime, a massive thank you for joining us. I hope that you found that interesting, useful, and it leaves you with a little bit of confidence about data protection in your everyday job. So if you need anything, reach out. But in the meantime, have a lovely afternoon. Stay safe, and we'll see you at the next one.